Friends, today I want to talk about an idea for improving the judiciary, which may seem a little futuristic, but actually it is not futuristic. The future is already here, the technology is already here, and everything that we need for implementing the idea is already existing. The topic that I want to talk about is the possibility of replacing human judges with artificial intelligence, that is computer, internet and artificial intelligence programs which are specific for deciding cases. Now let us understand the theory behind this. Already there are programs which are in charge of scheduling cases, and we have already effectively handed over that part of the judiciary to the software. Software is taking care of that part of it. Now, why don't we hand over other parts of the judiciary also to softwares that are capable of applying logic to the existing laws and the existing evidences and facts of the case in a quick and timely manner. Such a software would require inputs of evidences, of documentary evidences. It would require inputs of facts of the case from both the parties. It would require sworn testimonies from witnesses. Even the cross-examination of witnesses can be fed in as inputs to the system. And at the end of this, it should not be a very lengthy process. The software would give out an output, an order or a judgment. What is wrong with this? As far as I can see, this would actually be more effective than having human judges. And I'll tell you the reasons why. Judges are like highly defective softwares. Human judges who are there at the moment are like highly defective softwares. They are defective for multiple reasons. Number one reason why they are defective is that they themselves have too many opinions. They have their own philosophies, they have their own biases, and they bring their biases into the courtroom. Some judges are very impatient. Some judges have difficulty in listening and reasoning and understanding the facts of the cases correctly. Some judges are very opinionated, very authoritative, very egotistic. Some judges try to impose their own mindset onto the case, onto the litigants. They try to overwhelm the litigants. Some judges have leanings towards, for example, giving stay orders to certain parties. They have leanings towards some senior counsels. Now, a judge should have no leanings, whether it is a senior or a junior that is appearing before him. Whether the person appearing before him has a pleasing voice or a rough and rude countenance should make no difference to a judge. The only thing that a judge should be interested in is the facts of the case the law and what logic dictates. This is what judges should be interested in. They shouldn't be interested in anything outside this, but they are. They are interested in who is the senior counsel, who is appearing for the litigant, what is the litigant, who is the litigant, is he a big shot, is he a small man, is he a scheduled caste, is he a Brahmin. They have all kind of biases. Is it a corporate, is it a single individual, is it an activist? They have biases, they have huge biases. So this actually is a huge defect. It is like a defective software. A judge or judges with their different biases are like defective softwares. The fact that you expect different outputs from different benches shows that there is a defect in the software. Benches should make no difference. If all judges were similar in their behavior, in their thinking, then there should be no difference between one bench and another bench, one judge and another judge. But that is not the case. So, what is being admitted by the system itself is that judges are individualistic, they are biased. Essentially, they are like defective software, defective logic motherboards, defective computers. Now, what are the things that are expected from a judge? Let us understand what is justice, just from a layman's perspective. And we'll try to generalize about justice, which is the output of a court. In a criminal case, there is an accused person, there is the prosecution side, there are evidences, there are witnesses, there are laws, applicable laws. Now the judge has to decide, the court has to decide whether the accused is rightly accused, whether all the laws that are applicable to the facts of the case are indeed applicable, and it has to verify the facts of the case. It has to verify, it has to examine the evidences, whether the evidences are genuine, whether they will hold, they are logical, whether they are they should not be forged or they should not be fabricated. It has to be verified. Now that is all there is. Witnesses have to be examined. Witness statements have to be examined. Cross-examinations have to be understood, and the results of the cross-examinations have to be assimilated. In the light of the available laws, the evidences have to be examined, and the accused has to be, the offense of the accused has to be established. And based on that there is either acquittal or sentencing. This is what criminal law is all about. On the civil side, you got two disputing parties. One of them has a claim. He provides evidences of his claim. The other side, the side which is defending against the claim, may have counterclaims. They will provide evidences of their counterclaims. There would be witnesses, there would be evidences. Applicable laws have to be applied, or rather, in the light of the laws, the light of the overall legal framework and the laws that are being invoked, the judge has to decide whether one side is right or partially right or wholly right, or whether it has to be rejected or whether it has to be allowed, whether the prayers have to be allowed. This is what the civil side is. Then there is the appellate procedure. If something has not been appreciated, if the facts of the case have not been properly appreciated by the bench, then that may be disputed. Or if some legal provision has not been properly understood, etc., etc. So, appellate. Now, all this has to be done in a time-bound and reliable manner. I would argue that currently the courts are neither time-bound nor reliable. It is completely an arbitrary exercise. There's lots of haphazard processes. Suddenly the bench changes and everything changes. One judge has been going in one direction, the other judge goes suddenly in an opposite direction. One senior counsel comes into the case, and the course of the case changes. So it is not reliable, it is not logical. Is it time bound? Again, answer is no. It is not time bound. All the time goes in procedures. Why? Because so many human beings have to come together and be heard. A lot of a judge's time is spent without fruitful hearings. There are so many reasons why it is not time bound. And because it is not time bound, courts become essentially meaningless places for the common man. Now, what about artificial intelligence? Artificial intelligence, or just for general public's understanding, I'll say it is a self-training software. Artificial intelligence is a software that trains itself, that writes new code into itself to avoid its own defects and deficiencies. It's a self-correcting software. Now, artificial intelligences have been used, for example, for many years, have in various ways and different models of learning. They have taught themselves chess, for example, how to play chess. Millions or billions of permutation combinations must be assimilated. There are different ways in which chess engines operate, different types of chess engines. They play against each other, and it's a very intelligent thing. It's a very intelligent thing. It rivals human intelligence. It in fact beats human intelligence. Where a judge would take hours and days to come out with a judgment, a software, once the details have been fed in, once the evidences and the facts of the case, etc., have been fed in, would probably arrive at a judgment in hours or minutes. Not even hours, in minutes and seconds, almost instantaneously. Another advantage of artificial intelligence and software is it can be calibrated. These systems can be tested. You can't test a judge. You can't test a court. Judges refuse to be tested. They don't want to be tested. I can say with reasonable certainty that some of the judges are borderline insane or borderline senile, or there are lots of problems with them. They are fairly illogical beings, and the fact that everybody addresses them as milord makes them egotistic, and that egotistic kind of a mindset is not conducive to logic. So you have habitually egotistic, illogical persons who are masquerading as logical persons. They defy calibration. They defy testing. Whereas a software, an artificial intelligence software, a computer, can be calibrated. You can feed test cases into the computer. You can feed a test case where the outcome is already known by the engineers or by the software developers. For example, let us say a murder case where you already know who's the murderer, and then you construct the case backwards, and then you create gaps in the evidence, and then let us arrive at what point will a case, with what evidences will a case result in a actual conviction, and if there are gaps in the evidences, at what point will the whole thing result in an acquittal. A fairly robust system can be built, and it would be a self-correcting mechanism, it would be a self-correcting system, so that the justice system would actually get better year after year. Currently, with the human systems that we have, the justice system, the judiciary, progressively gets worse year after year. It's getting worse and worse because backlogs are growing. And because corruption is becoming more subtle, and because the economy is becoming more and more difficult to understand, and because judges are more and more out of touch with the modern day realities. Judges don't seem to understand softwares. Judges don't seem to understand the modern ways of doing business. They don't understand the new corporate environment, the international business environment. They don't understand it. Judges are clueless. Judges are clueless about the implications of information and communication technology. As I said earlier, they are clueless to understand what is publishing in the modern world, where anybody can self-publish. Anybody with YouTube or anybody with a blog can publish and become viral and can be known overnight, and he can make his views known overnight. The judges are clueless. They have no idea of jurisdiction. There is so much that the judges fail to understand because they are not exposed to this. They are not exposed to these technologies. They are not exposed to the multiple dimensions of these technologies. And these technologies are developing month after month, year after year. For example, take Snapchat. If you have decency and indecency laws and molestation and outraging a woman's modesty and things like that, I know a little bit about Snapchat and the way it functions. People can send nudes to each other, and then that picture, once seen, gets deleted. It vanishes. Did he outrage her modesty? Did she outrage his modesty? Did they have consensual exchange of pornography? What was it? You can't even define it. In the old terms, you would be left with some kind of evidence. Here you have nothing. People send dick pics. Bam, it disappears. What happened? Is it an offense anymore? What is the jurisdiction? Someone sitting in UK sends a dick pic to a girl in India. The jurisdictional issues that arise from this are amazing. You can't handle it. What I'm trying to say here is this: our judges are out of touch with modern day reality. They are out of touch with the fast evolving electronic communication environment. They are out of touch with the new ways of doing business, which spans international borders and actually gets done in a space that it is not on any border, it is not in any territorial jurisdiction, it gets done in cyberspace. Judges are completely clueless. Now, it does not have to be so. If you have a quickly updatable, self-learning, self-correcting software program, which will be maintained by the most modern brains rather than the most aged, borderline senile, on the edge of retirement type of brains that populate our high courts and supreme courts, then surely the quality of justice would improve. So what am I saying here? What I'm saying is this: it is necessary for us, the time has come for us to demand a complete modernization of the justice system, the judicial system. The time has come for us to demand that the judiciary should be automated, should be made not just computerized, but should be based on artificial intelligence. In the same way as the stock exchange is based on artificial intelligence and algorithms. Stock exchange is stock trading nowadays, commodity exchange trading, all these trades happen with the use of highly advanced algorithms and artificial intelligence. And in the context of all this, should any errors arise, such errors can be found, detected through calibration. There can be a continuous effort at calibrating these, the judiciary artificial intelligence, so that the system becomes more and more robust, more and more reliable, and more and more timely. The time has come for us to give up our hang-ups and demand this. Good night.